Andrew Rosenberg Law. Clear plans, peace of mind. Andrew Rosenberg Law. Plan it right, protect it all. Andrew Rosenberg Law. Guiding you when life gets hard. Andrew Rosenberg Law. Peace of mind, secure your future. Andrew Rosenberg Law. If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andrew Rosenberg. Andy helps South Florida families protect what they've built, avoid messy legal problems, and make sure their plans actually work when life takes a turn. I'm Lisa Mosbey, your host, and today we're talking about how your home is treated under Florida's Medicaid rules and what you can do to protect it the right way. Welcome back, Andy.
Hey, Lisa, how are you?
I'm doing great. I'm so excited to get into some of these conversations about our properties in Florida. How does Florida Medicaid view a person's primary residence when they apply for long-term care benefits?
Yeah. Well, first off, I got to introduce my guest speaker today. It's on my shoulder. We got Gary over here, my favorite golden doodle.
Yeah.
And he's just wanted to join us today. So if everyone's watching the video, they can see Gary. But let's get back into it. This whole topic is really confusing. And it's very, so I got a caveat here. The caveat is Medicaid planning is very complicated and confusing. So you need to meet with an elder law attorney, which is what I am. But in general, if you or your loved ones or your family are considering assisted living care, nursing home care situations, and you don't have long-term care insurance, and you want to try and protect assets, then this is where that Medicaid planning comes in, and that's the issue. So this Medicaid process is really confusing process. I just want people to understand that. Now, the home, at least in Florida, the general rule about the home, but when we say home, I'm talking homestead property, okay, for Florida, is that it's exempt. They don't count it for long-term care, which is great. Now, there's obviously caveats to it and all sorts of things, but in general, the home's not counted, which is a wonderful thing. So people are always worried about how they're going to lose their home with a nursing home and stuff. And the general rule is if it's done properly and if things are set up right, you're not going to have an issue.
Now, you said it's the general rule, so it's not always protected. What situations can put a Florida home at risk of recovery or a claim later on?
Yeah, well, that's, this is the whole topic today is that. So what you need to understand is that the general rule is homestead property is protected in Florida for Medicaid purposes, meaning they can't touch it. Now, the rule is it's actually limited by the amount of equity you have in them, okay? So Florida says that they won't come after any of the house when you pass away if there's $730,000 or less of equity in the house. So if you have a $5 million house, they could potentially consider coming after it. Now, the only way they can come after it is if it goes through probate court in Florida, okay? So if it's in a trust or if we do ladybird deeds, etc., it's usually protected and we don't have that issue at all. So I know this is really confusing and I'm trying to explain it in a way that makes sense, but you guys just bear with me. So what happens is the way the Medicaid laws are written in Florida, Medicaid, the state of Florida, what they pay for the nursing home. If you have no money, you have no assets, etc., and they're paying for everything in the assisted living facility or in the nursing home, and then they pay for a lot of money, over the years for you, and then you pass away, they want to recover money from that. So how do they recover money? Well, by Florida statutes and laws, how it's written, the only way they can really come after that is it's whatever has to go through probate court. So if an asset is technically not going through probate court, they're not going to be able to come after it through the Medicaid Asset Recovery Program. Did that make sense?
It does, absolutely. I didn't know that about it being safe in a trust and there is no probate. I didn't know that.
It's safe and it's not safe. I mean, there's other rules and stuff, but the general rule is that it's safe.
So, Andy, does it change if somebody is still living in the house?
Yes. Yes and no. So there are exemptions, right? So one of the exemptions about homestead is the equity amount we just talked about, right?
Yeah.
The other exemption is if you're married and let's say one spouse is going to the nursing home or assisted living and one is going to live at home, you could have a multi-million-dollar house. The whole thing's exempt. They can't touch it.
is.
So when the survivor passes away, that's in an assisted living or nursing home, they can't touch the house. It's protected. Another exemption would be that if you have a disabled adult or a child under 21 that is in the house living there permanently, they can't touch the house no matter how much equity is in there. So there's all these crazy rules when it comes to Medicaid. And that's why it's really you got to be real careful about how things are done. And you mentioned something, Lisa. You said, you know, are there ways you can screw it up? And there's lots of ways that you can screw this whole thing up. Okay. Can I give you one quick example?
Yeah,
I
let's
know
do an
we're kind
example.
of jumping all over the place. Okay. But let me give you a quick example. I see this a lot. Mom's a widow and mom's got 3 kids and, mom's not doing well and the kids are concerned about it and that mom doesn't have long-term care insurance. Again, the best way to pay for this is long-term care insurance, but no one has it, by the way. Just so you know, I meet with clients every day. Okay. Every day I meet with new clients and I would, on average, guys, 99% of the people I meet with do not have long-term care insurance. It's unfortunate, but I'll tell you why. It's too damn expensive. It is so expensive to have long-term care insurance. I have it, okay? And I'm paying an arm and a leg for it right now to protect, but I have it. If you don't have it, you're
I
going to
don't.
pay. Right. So your assets and your income are going to pay until they get down to nothing unless you plan accordingly, right? And that's the whole purpose of Medicaid planning. But what I was saying is the widow example, right? We got a widow who's not doing well, got 3 kids. She owns a house and not much else, maybe a small bank account. And the kids are trying to think, you know what? We need to protect mom. We need to move her into an assisted living and nursing home. We're going to transfer the house from mom to us, to all 3 kids, which makes sense, right? And now mom doesn't have it and it's done. That's a disaster.
Yes.
And do you know why, by the way, Lisa? You want to guess?
I do, because there's no step up in basis.
That's one disaster, and we didn't even talk about that, but that's not the one I was thinking of.
Oh, okay.
Now mom goes into an assisted living or nursing home. That whole transaction is voided.
Because it wasn't within the 5-year look back. It happened within
Yeah,
the 5-year
yeah.
look back. Is
It
that
was
it?
a
Okay.
gift. It was a gift
Yeah.
to the kids, right? They transferred the property for $10 or whatever to the kids. And it was done within 5 years before mom went into the nursing home or assisted living. It all gets clawed right back. That's the
Okay.
issue that everyone knows about, or they hear about this, quote, 5-year rule. That 5-year rule is as follows. Anything that you transfer gift-wise to family, friends, kids, whatever, anytime you do a gift, the state, when they want you, if you want to try and qualify and have the state pay for Medicaid or get you qualified for Medicaid for a nursing home or assisted living, they're going to look at all investments, everything, and they're going to look back 5 years and see if there's any funny transactions going on. And if there is, you get penalized. And the penalization is as follows. It's whatever you transferred divided by, I'm just going to use this number. It's not quite this number, but $10,000.
Okay.
So let's say that the house was 300,000 and you transfer it in this widow example, and we transferred it the whole 300,000 to all 3 kids, right? You know, the whole thing. So a third to 3 kids. That was a $300,000 gift. Take 300,000 divided by 10,000. That equates to 30. That's a 30-month penalty for you to get onto Medicaid. Medicaid says you qualify, but for the first 30 months, you're going to have to pay. That's
a big
works.
mistake.
That's a huge mistake. And the other big mistake is exactly what you said. The other mistake is by doing that transfer, which is done every day. I see it all the time. They think they're doing the right thing. They're trying to get something out of mom or dad's estate. That transfer, they lose that stepped up death benefit basis, which most people don't understand. Again, mom bought it for $50,000, the property. It's now worth $300,000. There's $250,000 of growth there. Mom transfers it to the 3 kids because the kids think that's the right thing to do. And now there's a 5-year look back problem, right? In addition, when the kids sell it for $300,000, when mom died, they're going to have a $250,000 capital gains tax that they have to pay taxes on. If they held on to it, mom held it, and then when mom passed away, it goes to the kids at fair market value. It's called stepped up death benefit for $300,000. The kids would get it at $300,000. They'd wash away the entire $250,000 capital gains tax. They could sell it the next day, no capital gains tax. So that's the other problem when you do that gifting issue, is you lose that gift, that stepped up basis.
I see those 2 places, the taxes, the step up in basis, and making that bad decision, transferring it to the kids' name. Are there other areas where people can get into trouble?
Yeah. So here's another example. I know we're all over the place today. I apologize, but it's just a crazy topic. Widow, right? Widow is there, and we got the 3 kids. Instead of transferring the property to the 3 kids, the kids say, you know what, we're going to move mom into the nursing home, and we're going to rent the property out.
Oh.
That sounds like a great idea. It's income, and they can help pay for things. Guess what? Now the exempt asset, which is the homestead property, right, is now non-exempt because it's now an income stream. So now they won't count the actual value of the house, the $300,000 value of the house, but they're going to count that income of $3,000 coming in a month from the rent. That's now going to cause a problem. There's a bunch of ways to qualify for Medicaid. The 2 big issues are your assets and your income. If you make too much income, you no longer qualify. If you have too much in assets, you no longer qualify. So that's why you got to keep the assets very low, and then the income's got to stay low. So if we now increase the income, the odds are that we have blown the income threshold, and now we've lost Medicaid because of income purposes. So that's just another example of how quickly things can get screwed up with this whole process.
Here's where I want to go with this is we've talked about what can go wrong, many different ideas of how it can go wrong. So it's obvious to me folks can't do this on their own. You do absolutely need an estate planning and preferably an elder care planning attorney. So what are some legitimate planning tools families use to protect their home without violating Medicaid's transfer rules?
Okay. Great question. If for Medicaid purposes, there's 2 main areas for the house, for the primary residence, to protect it. One is called a Medicaid Asset Protection Trust. It's called a MAT. Okay. Medicaid Asset Protection Trust. And what it is basically is we set up this irrevocable trust. Then we transfer the house into the irrevocable trust. And then hopefully nothing happens for the widow in our example we've been using today. Nothing happens for the next 5 years. After the 5 years, it is now out of mom's estate, the widow's estate, and it's gone, and it's not counted for Medicaid purposes. So that's one of the planning strategies we do. What I think is the better one most of the time, and the much easier one, is something called a ladybird deed. And I know we're going to talk about it in another podcast soon, but in general, what happens is it's another way of transferring the property to your family members, to your kids, or wherever you want it to go overnight, basically, and it's no longer going to be counted for Medicaid purposes. And when you pass away, it doesn't go through and have Medicaid recovery system come after it. So it's actually a perfect vehicle, but not always perfect. And you have to listen to the next podcast whenever we do that Ladybird podcast to talk about when it's not perfect, because there's lots of problems with the Ladybird. Again, disclaimer, this is general stuff, guys. Every case is unique and every situation has unique flaws and issues that we have to deal with as the elder law estate planning attorney to make sure we try to plan accordingly, because there's lots of issues that crop up.
For sure. And Andy, for someone who wants to plan ahead and keep their home safe, what's the best first step to make sure everything is done correctly and legally?
Well, I think obviously if you didn't get the gist of it from this workshop, you need to meet with an elder law attorney, okay? Not an estate planning attorney, I'm an estate planning attorney and I'm an elder law attorney. There is a distinction, okay? An estate planning attorney deals with what we want to do to deal with avoiding probate, doing wills and all that stuff. An elder law attorney also knows all the rules and issues relating to Medicaid. And how do you plan accordingly to make sure we get mom, dad, brother, sister, whoever qualified for Medicaid, for nursing home, assisted living. It's a really different and unique situation. So my suggestion for anybody is twofold. Number one, you need to understand this if you live in Florida. If you have mom, dad, brother, sister, spouse, whatever, if we have to deal with assisted living or nursing home, just realize there is a 5-year look back period, but there's also, if the elder law attorney knows what they're doing, and if we can plan accordingly, we can do crisis Medicaid planning, and we don't have to wait the 5 years. I do most of the time, I'm doing Medicaid planning overnight, within a couple weeks, to get things qualified. So you just need to know in Florida that Florida is very good about allowing us as elder law attorneys to do crisis Medicaid planning. That's number one. Number two, don't do any of this stuff without talking to an elder law attorney.
Well said. And I think we'll leave it there for today's episode. Thank you so much, Andy.
I think we should too.
Folks, thanks for listening to If You Don't Plan, You're Stupid. Your home is often your biggest asset, and understanding how Medicaid treats it can save your family from unexpected problems later. If you want to build a plan that keeps your home protected the right way here in Florida, visit rosenberglawfirm.net to get started. And don't forget to leave a review, and subscribe to the show. We'll see you next time.
Take care, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.
If you